Friends, good afternoon to the afternoon session of the 9th day. We have with us this afternoon Mr. Arvind Narrain from Bangalore. Okay, this morning you had Hyderabad and Chennai, so you have a different flavor for the evening. You have Bangalore and later you'll have Delhi. Welcome, Arvind. He is the founding member of the Alternative Law Forum, Bangalore, ALF as they are popularly known, which started as a collective of young lawyers. He's still young, the founder, who work on critical practice of law in the city of Bangalore, for all courts. They have worked on human rights issues, including mass crimes, communal conflict, LGBT rights, and human rights history. Have been part of many fact-finding reports on sexual minorities in India, and was also part of the litigation team which argued the very famous constitutionality of Section 377 before the Delhi High Court and later the Supreme Court. His association with advocacy at the international level has involved significant collaborative work at the UN Human Rights Council. For some time, when he was based in Geneva, our meetings were always bumping into sessions at the Human Rights Council. And he has first-hand knowledge of how the international and domestic advocacy can be mutually reinforcing. I'm extremely happy that he's with us because he and the next speaker are both very experienced with the international mechanisms, developing of international standards, and then the use of these international standards in our local domestic courts. He's a graduate from the prestigious National Law School of India, University in Bangalore, and did his master's in the University of Warwick in the UK, and is the author of Queer, Despite Sexuality, Law and Social Change, and co-editor of Because I Have a Voice, Pure Politics in India, along with Gautam Band. He has also co-edited Law Like Love with Alok Gupta. Friends, I just want to give you a hint. Those of you who are interested in seeing how this international and the domestic meet and can be better understood, utilized in the branches or thematic engagements that we are engaged in. Here is an expert we have, a young lawyer, but also somebody who has played well with the international system and knows it now inside out. Thank you, Arvind, for accepting to be with us in spite of my late invitation to you. We are extremely happy that you have accepted, and therefore you can go ahead on Right to Love.
Thank you, Henry, for this invitation. And what I was thinking of addressing is broadly put the entire campaign in the Indian context of the decriminalization of same-sex relationships, which is broadly the campaign against Section 377 of the Indian Penal Code. And there are at least four significant, again, with the way I want to try and address this is, I think for all of you all to also think a little bit about, is that how does the law become relevant as an instrument of social transformation or social change? And I think my thesis will be, and I think Henry will completely agree with me, is that the change in the law can only happen if we have a social movement backing it. In the sense that you can potentially get a change in the law, which could be completely meaningless. And I think we can think of I think you would have discussed a range of Supreme Court judgments, I'm sure, in the course till now. The judgments which say, for example, what are the requirements the police need to follow an arrest being followed? What are the various other judgments in the Manual Scavenging Act? To what extent are they being followed? And the answer you'll come up with is that unless you have a way in which your legal campaign and social campaign go together, it's very, very difficult to ensure that finally there's change or transformation which happens at the ground level, which I think is all our interest, or the thing that we're all most interested in. And I want to take you through maybe a couple of key moments in this entire history The first moment, I think, is a moment which we all have to be very familiar with, unfortunately, which is 1860. 1860 is when the Indian Penal Code came into force, and why it's relevant is because the Indian Penal Code of 1860 is what still rules as far as this country is concerned. And if you want to think of why that is a problem, you can look at a provision like 124A, which is a provision on sedition, which is a part of the Indian Penal Code. You can think of a provision which is the criminalization of adultery, which is stuck down Joseph time, which again is in the. We have, of course, Section 377 of the Indian Penal Code as well.
Little slow.
Little slow, yeah. Thanks for reminding me, because often this is very important, because since I can't see you guys, sometimes we're very used to picking up on visual cues, right? And so nobody is visible. So thanks Henry for that. So and yeah, my problem is the more excited I get, the faster I go. So I need to like hold myself down a little bit and go a little more calmly. Okay, so we get back to the question of 1860. And 1860, there's a provision in the Indian Penal Code which is 377, which basically says whoever has carnal intercourse against the order of nature with any man, woman, or animal shall be punishable with life imprisonment or imprisonment up to 10 years. And the way this provision was interpreted the way the provision was used at the ground level was broadly to target LGBT people around the country. There were cases of blackmail, cases of harassment, cases of violence, all of which were perpetrated against the LGBT community. Again, it's a very important point in terms of thinking of the impact of a law, because if one of your guys goes through a search of all the cases under 377 in under 377 ever since the provision came into force, you might find a maximum of 200 reported decisions. You dig a little further into that, you will find out of that 200 reported decisions, you'll find 3 cases of consenting sex between adults. Rest of them will be cases of non-consensual sex. So again, the question which a lot of people will ask is, which a good lawyer will ask, end of the day, you're talking about a provision which is infructuous. Nobody is using the provision. Why are guys creating a song and a dance over a provision which matters not at all? And I think the answer to that again comes back to the way we think about the law. Section 377 is a provision. The problem with it is what we call not prosecution, but persecution. That's a very important distinction, because by prosecution, you mean an FIR is filed against you, a case is registered, and then you fight that case in court. That, for example, might be the problem under the Unlawful Activities Prevention Act and range of the anti-terror statutes. In this case, the problem is a case might never be filed against you. But what it does, it's a very important point. What it does is it creates a certain mindset, the way judges think, and the way, most importantly, policemen think about LGBT people. Because of the language of the law, which talks about carnal intercourse, and the language of the law, which talks about unnatural, there's a perception of LGBT people as being unnatural, animal-like, and that's the perception which moves from the law to a certain form of social reality and structures the lives of LGBT people in many, many ways. Structures or limits the lives of LGBT people in many, many ways. And again, if you look at the provision and deeply damaging nature of the provision, what should shock you or surprise you is that from 1860 till 1950, there was no challenge to the law because we didn't have the constitution in place. 1950 is the other key date when we have the Indian Constitution coming into force. Indian Constitution, with its guarantee of the right to live with dignity, of its guarantee of the right to privacy, with its guarantee of the right to equality. Yet, if you look at the interpretation of the Indian Supreme Court and the High Court, you'll see from 1950 to 2009, there's not one single judgment in which the Supreme Court or the High Court has said this provision has resulted in these forms of harm to the LGBT community, and therefore we will consider the impact it has in the LGBT community. It's complete silence. The first time the silence was really broken was in 2009. And that's the other significant landmark I want to go to. 1860, 1950, and 2009. In 2009, the Delhi High Court, in a judgment called the Naz Foundation versus NCR Delhi, delivered by Justice Shah, basically held that Section 377 violated the right to equality, violated the right to non-discrimination, violated the right to privacy and dignity, and 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 hence had to be read down. It is a very significant and very landmark judgment because for the first time you've taken a different track from the way the justices have till that time interpreted this particular provision. And I want to take you through some of the nuances of the judgment because it's very, very important. The Again, sometimes you get the sense of the judgment because of what happened in court. You get a sense from the way the judges were speaking. And I'll give you one thing which Justice Shah said, which really struck a chord as far as I was concerned. We were in court, and the government counsel made some particularly, offensive statement, which is to say the anus is a place used for excretions, not a place used for procreation, and how come these fellows do that? Da, 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 da. That's the way he was going on. And then Justice Shah made this point. He said, counsel, when we speak about the particular community, we often speak in terms of which despise the LGBT community, and we often know the kind of language which is there, often which emerges in during the coffee table breaks. Again, a very important, very, very nuanced way of thinking. He says, where does prejudice get exhibited? It won't get exhibited face to face. For example, in this class, right? Assuming that somebody has a different opinion, it won't be expressed face to face in most cases, right? It'll be expressed in the form of a cigarette break when people get together and they laugh or giggle or smirk. And he got that. He said, we think of sexuality with a smirk. And what his point is, you think of sexuality within the language of dignity. And his point was this: why is dignity, or how do dignity and sexuality come together? They come together in this particular way. Because end of the day, dignity is about protecting the choices you make, granting constitutional protection to the choices you make about your intimate life. Your intimate life could include your decision to have a child. Your intimate life could include your decision on who your partner should be. And Justice Shah's point is, when you make a decision about who you want to be with, that's a part of your intimate life, and it's a part of your dignity. It's a part of your autonomy of decision making. So the other point I want to make, which Justice Shah made, which I think is very important, again from the point of view of legal doctrine and thinking about the law on these points, is he linked dignity to the notion of privacy. And again, when we think of privacy, what do we think of privacy often as? When I say privacy, it'll be like often people will say, see, we respect the LGBT community to their right to do what they want in private, which means you go to your bedroom, do what you want in your bedroom. That's your business. It's not our problem. Justice Shah's understanding of privacy is, there's a zonal component, which is what I'm referring to, which is the privacy of your room, etc. There's also a decisional component. That is, when you make decisions about your intimate life, it's a part of your right to privacy. If you want to think a little more about this, the precursor really is the decision in Roe versus Wade. When you say a woman's right to abortion is part of the right to privacy, it doesn't mean that the right to abortion is about the right to do abortion in the bedroom or in a room. The right to do abortion is to do with the decision you make about your body, right? So it's a question of bodily autonomy. It's a question of bodily integrity, which is also part of the right to privacy. So one aspect of the Naz judgment is how you link privacy and dignity, how the two come together. Two other points I'll make about the Naz judgment, which I think are important, is the other point which the Naz judgment brought forward is they said that we need to root the rights of the LGBT community within the constitutional traditions of this country. And for that, they invoked the thinking of Baba Sahib Ambedkar, where in the Constituent Assembly, when in a statement which was forgotten, right, no judge in the Indian High Court or the Supreme Court had ever referenced this statement by Dr. Ambedkar in the Constituent Assembly. The statement was this. He said, he's referring to the idea of constitutional morality. And he says, constitutional morality is not a natural sentiment. It has to be cultivated. Democracy in India is a top dressing on a soil which is essentially undemocratic. It's really a very, again, this is where the power of Dr. Ambedkar's words comes in, because he's putting forward a concept which is deeply meaningful for all groups and minorities fighting against forms of societal tyranny. Again, you think back to Dr. Ambedkar's work. You think of Article 17 in the Constitution. What is the idea behind Article 17? Article 17 is to criminalize the practice of untouchability, which could be in the sphere of private society or it could be in the sphere of society itself. So the idea that the Constitution will take seriously biases and prejudices which are embedded in the societal order itself. So when Justice Shah invokes Dr. Ambedkar, he's making the point. He's making the point that in our country, because we're bound by the Constitution, popular morality or popular prejudices, however strong they may be, however widespread they may be, have to give way to the idea of constitutional morality, which is the idea of the dignity of a section of the population, however unpopular they may be, cannot be sacrificed at the hands of a popular majority. So the broader conceptual point he's making is India is not a majoritarian democracy, it's a constitutional democracy. Again, this has great implications for the way we think about the future of this country in the time going forward. Just because you're a majority does not mean you will always get your way as far as the Indian Constitution is concerned, especially when your majoritarian prejudices or sentiments seek to interfere with the right to dignity or life of a certain section of the population. The other thinker who Justice Shah invokes, who's forgotten today, but also very important, is Nehru, who made the point. He again, in the object, when he's moving the objectives resolution, he made the point of the inclusivity being at the heart of the constitutional order. Again, Justice Shah's point is that when inclusivity is your value, then you must create a space for the LGBT community. There's no way out of that. So you see the way he's taken the conversation out of the smirks, when you talk about sex with a smirk, right? Or you go to when you're having a cigarette, and then you're making fun of the LGBT community, saying no, we need to think of it within the constitutional tradition of constitutional morality and inclusivity. So that's a significant contribution Justice Shah made in thinking over the rights of the LGBT community. That's in 2009. But then, as you can imagine, that, and I'm sure as you know, that this was not an easy battle because you're challenging deeply held social prejudices and a social mindset. And within the first 7 days of the judgment, the first appeal was filed against the Naz judgment. And within the next year or so, 15 plus appeals were filed against the Naz judgment. If you looked at all the appeals, there's one interesting factor about all the appeals, that it was a purely secular appeal. Secular appeal in the sense that the Hindu, Muslim, and Christian fundamentalist groups were all there opposing the reading down of Section 377. So when that happened, again, for you all to think about in terms of strategic thinking, what does one do? You have, in a sense, as far as the judges are concerned, you have all the major religious groups which have come out in strong opposition, and there's one small LGBT community stuck in some corner of the other. So how do you build a sense of support for this particular community? And so the thought we came up with is, can we think of filing interventions supporting the Naz judgment? And we filed 3 interventions. One was the parents of LGBT persons, one was by mental health professionals, one is by teachers. And the parents' intervention is making the simple point that the other side's argument is 377 is against family values. And the argument of the parents is that 377, what it actually does is it deeply impedes our ability to enjoy family life. Because what 377 does is, as parents, gives me a sense of fear. I'm fearful whether my son or my daughter is going to return home today in the evening or tonight. We don't know if the person is going to get arrested or picked up by the police or what. There's a Damocles, 377 is like a Damocles sword hanging over the heads of our children. Then they went on to make the point that it's actually 377, which is an impediment to free and open communication with me and my children. Because my children are scared to communicate an integral part of who they are, because the law criminalizes their very existence. And the mental health professional made a similar argument in terms of saying that the uh, current, shall we say, scientific consensus is that it's not a disorder anymore. So anyway, these are the, just to give I spoke a little more about the parents' intervention. I want to speak about the other two because we don't have that much of time. And we filed these interventions. 2013, the arguments came up, Justice Singhvi and Justice Mukhopadhyay. And I think in some ways of saying, in 2009, if we got the two best judges in the entire wide world, in 2013 we got the two worst judges. And just that's, I guess, the luck of the draw as it goes. And as the luck of the draw goes, they struck down the NAS judgment and restored Section 377 to its full force. And the argument they made was threefold. Firstly, they said that they said it's a minuscule minority. They said these so-called rights of the LGBT community. And finally, they said that let Parliament decide. Why are we deciding this matter? Again, the point to note is, who put it very, very well is Vikram Seth, who on NDTV, I think he made the point. He said that this is a bad day for law and love. Why is it a bad day for love? It is a bad day for love because we criminalize an intimate aspect of a person's life and say you can't express who you are. If expression, and if you can't, and if you take the argument of mental health professional, they make the point that your right to intimate relationships is part of your right to happiness. Human happiness comes from your ability to establish these sometimes profound relationships with people who you choose to love. And if you interfere with that, you're creating a block as far as the future of human rights of this particular person, particular grouping is concerned. So that was the argument of why it's a bad day for love. I don't think I need to explain more about why it's a bad day for love. I'm sure all of you guys agree that it is a bad day for love. Why is it a bad day for law? That's a more difficult question to answer. And the judges have answered it very well, actually. Again, the judgment you must read, it's a very long judgment, but the judgment you must read is the Justice Chandrachud's plurality opinion in the privacy judgment, Putuswamy. And there he comes out with a critique of the NAS judgment, of the three legs of the NAS judgment. When he says so-called rights, he says these are not so-called rights. These are real rights dwelling in privacy and dignity. Secondly, when he says minuscule minority, he says the Indian Constitution does not care about the fact whether a minuscule minority or a massive majority. All persons are entitled to fundamental rights under the Indian Constitution, even if you're a minority of one. So it does not matter. Minuscule minority is not a relevant category in the constitutional sense. And the third contention of Kaushal, which is the idea that let Parliament decide. Here again, he gets to the heart. What is the Indian Constitution? He says that in a country which may be majoritarian, it's the responsibility of the judiciary to protect the rights of unpopular minorities from the ravages of majority prejudice. He puts it much better than that. I am not getting the exact words as we speak. But the broad point he's making is that we can't allow the rights of a minority to be subject to the prejudices of the majority. And it's the responsibility of the judiciary to protect and defend the rights of unpopular minorities. Again, this is a great significance in the time going forward because we expect and we hope that the judiciary realizes its constitutional responsibility. It's not to be a sidekick of the executive. It's not to pat the executive on the back. It's not, as the former Chief Justice seemed to indicate, it's not to build those good relationships with the executive and the judiciary. The role of the judiciary, as understood under the Constitution, is to protect the rights of a minority even against the prejudices of the majority. This is an important point because at the end of the day, Parliament is a majoritarian institution. It represents the viewpoint of the majority. It is in that context that the role of the judiciary in terms of protecting the rights of minorities becomes even more important, even more powerful. But that is 2013. We got a bad judgment, and we had a very, very, very strong campaign against it called "No Going Back," which broadly was making the point that we're not going to go back from the position we got to. And one of my friends, Akhil Katir, he was narrating on the first day of the after the judgment. He was narrating this poem poem by a Black American gay poet called Langston Hughes. It goes like this. He did it in Hindi. I'll do it in English, since I can't do it in Hindi. The English poem goes like this. It's called A Dream Deferred. It goes like this. What happens to dream deferred? Does it dry up like a raisin in the sun? Does it run like stinking meat? Or does it explode? And his point, he said that the Supreme Court may set us back, but this dream will explode. They can't keep us down. That was his broad point, and that's what we saw from 2013 to 2018 when the page was decided. We had a strong campaign which took forward the issue in a very, very powerful way. We had more and more people who began to be supportive of the rights of the LGBT community. And in a sense, we got a far stronger support post the defeat than if we got a very narrow victory. Again, this is something all of you guys should think about, because sometimes a defeat can be a route to victory. Because what is our point? Our point, end of the day, is we want to get society thinking about this issue. We want to get people thinking about this issue. We want to get people to understand and accept LGBT people as full citizens. And if that is your objective, if you get a bad judgment and you're able to mobilize against the judgment and get more people on your side, that's one way towards achieving your ultimate objective. Okay, I'll stop with that and end with the last point, which is the most important one, which is 2018. 2018, we got the Navtej judgment finally. And I just want to make a couple of points about the Navtej judgment and end it with that. In some senses, if in 2009, if you'd asked me, will you get a judgment like this, I would have said no. And a judgment way beyond our expectations. And I would have said, you can't do better than NAS. NAS has covered all the bases. It's got dignity, it's got non-discrimination, it's got equality, it's got the invocation of Dr. Ambedkar and constitutional morality. Can you do better than this judgment? There's no better judgment on this issue in any other part of the world, is what I would have said, right? And interestingly enough, Navtej takes a couple of steps forward, and that is to the great credit of the judges. Because I would have said there's no way you can get better than NAS. What does Navtej get, which NAS didn't have? I just mentioned these 2-3 points, and then we can open it out. Apart from its invocation of privacy, dignity, equality, what Justice Indu Malhotra begins with is a very important point. She says, history owes an apology to LGBT persons and their families for the violence and ostracism that they suffered down the centuries. And again, you think about this, I know if Henry will agree with me, it's an utterly unique way of beginning any judgment. Any judgment begins with a petitioner. It'll tell you who the petitioner is, and it'll tell you what we're going to do as far as the petitioner is concerned. In this judgment, it's 500 pages. Anybody wants to read it, please do read it. And tell me what the judgment says about Navtej Singh Johar. Are we any the more wiser about who this guy is? We're not. Because the judges believe that this is about the LGBT community. Navtej Johar may be a cipher, may be a figure. He represents, or he stands in, for this much wider, much more diverse reality of the LGBT community in India. So a judgment which places itself in almost world historical terms. It says that history was an apology to LGBT persons and their families. So the apology dimension is a very, very important dimension of the Navtej judgment. The dignity dimension is as powerful. I'm not going to repeat that. There's equality. There's non-discrimination as well. And I'll just make one last point on the non-discrimination point and end on that point. When we refer to the idea of constitutional morality, the idea is really that how can a judgment trigger a way of change in the way society thinks? That's absolutely vital. Navtej recognizes that point because in their description, in their analysis of non-discrimination, Justice Chandrachud says that the problem with the non-discrimination law is also against the idea of prejudices encoded in the law. So why does the 377 violate Article 15? It violates Article 15 because Article 15 is a guarantee of equality and a guarantee against stereotypical perceptions of yourself. So 377 encodes the stereotypical perception of LGBT persons, therefore it has to go. So where it finally goes through is saying that the role of the government, it ends with the role of the government, is Justice Nariman's opinion, that the union government and the state governments have a responsibility to take forward the judgment, popularizing it by all means at their disposal, and we have to conduct training programs for police officers and government officials so that we can deal with this prejudice and discrimination which is still there. I'll end with that. Yeah.
Thank you, Arvind. Thank you. I will come at the end. I'm sure there are lots of questions which have been lined up in our chat. Rajvel, do you have the questions?
Yes. Thank you, Arvind.
We have almost 10 to 12 minutes, 13 minutes for questions. We hope, Arvind, you'll be able to take about four or five of them as they have come.
Sure.
Little slow, Rajvel.
Sure. So, Arvind, there are three questions, and they are interrelated also. The first one is, what is the status of legal status of same-sex marriages in India? And the next question is, so we have seen judgments from NAS to NAPTEJ, and the judgments have highlighted the right to equality. And that being in place, surrogacy bill doesn't allow same-sex couples to have a family, plan a family. And where do we stand legally at that point? And if another question is that if we don't recognize the rights of LGBTQI, isn't it contrary to Articles 14, 15, and 21?
Sure.
Over to you.
Yeah. Thank you. On the question of marriage, the judgment is in a sense, it's a narrow judgment, because you're talking about reading down a section 377 of the Indian Penal Code. And if you read Justice Chandrachud's opinion, he says the reading down is on the basis of the right to equality. He summarizes the law and relationship and marriage from around the world. And he seems to indicate that the path is towards marriage. That is the path which is out there. He's not saying it in this judgment, but I think using this judgment as a basis in the future, when somebody becomes Chief Justice, this might be a way of taking this particular issue forward. That's one point. But the other point I want you to recognize is marriage is a complicated question in the Indian context for two reasons. One is because we have the personal law. We have personal laws, as you know. So we can't talk about amending or modifying all personal laws, but we can talk about amending or modifying the Special Marriage Act. That's one possible route is the amendment of the Special Marriage Act to insert the word. It already has the word person, but remove the reference to bride and bridegroom in the Special Marriage Act, and then you'll be set. That's one way of looking at it. But the other problem to think about is the marriage law has come about in the context of the recognition of the unequal relationship between man and woman, with the biases and the prejudices that it entails. Is the same law suitable, applicable to the LGBT community is a question which people need to think about and debate. Give you two examples. One is, if you have a provision such as restitution of conjugal rights, do you want that to apply to members of the LGBT community as well if they choose to get married? A provision called adultery. You want that apply as well in the same format as far as members of the LGBT community are concerned. I don't have answers, but I have questions. I think this question of marriage has to be thought through a little bit more strongly and saying, what is it you want? Is the way forward a civil partnership law, which applies, for example, equally to all persons, straight or gay or whoever it might be. So which means that you get outside the framework of marriage and open out a different way of relationships, even as far as straight people are concerned. That's one possible way of thinking about marriage. Surrogacy bill, I completely agree with you that, again, for those who choose to celebrate the fact that this government did not put forward, did not oppose, we should be thankful to this government because they did not oppose 377 in the courts. They've shown their thinking in terms of the surrogacy bill, in terms of the trans bill, in terms of range of bills. Surrogacy bill and the kind of stereotypical notions you're encoding of the heterosexual family is deeply problematic in the context of NAPTEJ. 100%. I completely agree with you. And of course, the challenge to the bill cannot be the level when it's a bill, when it's a law and it's passed. That's when the ground for challenge on the basis of NAPTEJ opens out. And I think it's an important challenge one will have to consider. The third point about is Section 377 a violation of Articles 14, 15, and 21? Yes. Maybe I'll expand a little bit on the dimension of each of these. 14, if we can take 14 a little beyond the question of the classification principle itself and look at the substantive idea of equality, that will be one way of thinking about 14. Article Article 15, I just mentioned that the question of what does sex mean, right? Sex could include sexual orientation, could include gender, sex includes sexual orientation and gender identity, post-Nalsa judgment as well. But the larger point might be that does it also include your right to be free from stereotypical ways of perception of the LGBT community, right? And that's the interesting part of the way Article 15 is opened out, especially post the judgment in Anuj. If you guys have read Anuj, that's the judgment to read, which gives you a sense of what stereotypes and Article 15 are really about. And 21 is really the linkage between two concepts, privacy and dignity, and how they relate to each other, which again I've expanded upon. And privacy again has three dimensions to it. One is relational privacy, zonal privacy, as well as I forget what is the other one. I'm forgetting. I'll come back to it. And dignity. The way these two concepts relate.
Thank you, Arvind. And so there are repeated questions on, it's a bit off topic on what we have been talking till now. And it's about the transgender person bill.
Yeah, no, that we should talk about. I'm happy to talk about that. Yeah.
Your comments on that.
No, I'm sorry. I mean, I should have clearly referenced one very, very important point which I left out in the entire narrative and story, which is the 2000 and Nalsa judgment in 2014, which just came a couple of months after the Suresh Kumar Kaushal. And the Nalsa judgment was a very, very important judgment, because what it did is, in a constitutional sense, it expanded the idea of what is expression, right? Again, we know, right, the freedom of speech and expression. We know what speech is. We think we know what expression is. But Nalsa gives expression another dimension. It says expression is also about your right to dress, attire, and ways of behavior, right? So if you're a man and choose to dress as a woman, if you're a woman choose to dress as a man, all of this comes within your right to freedom of expression under Article 19. And that Article 19 right is very closely linked to Article 21, right to life and right to liberty. So it's a very important way Nalsa conceptualizes transgender people's rights. And the other important point Nalsa makes is it recognizes your right to what we call self-recognition. Right? You have a right to self-determine, self-recognize, self-determine your gender, and your right to be recognized in the gender of your choice. Nobody can tell you what gender. The state cannot tell you what gender you should live in. Right? And this again is your right to recognition before the law, which is a very important component of your rights under Article 14 and Article 50. When we come to the transgender persons bill, it's a very important point which you brought up, and thank you for bringing this up. It's a complete violation of your right to self-recognition under NALSA. NALSA gave us rights. The transgender bill takes those rights away. And what it does is basically it says that if you want to be recognized as a transgender person, you have to go before a district magistrate with a certain number of certificates based on which you can get recognized as a transgender person. If you want to get recognized as male or female, you first get a certificate as a transgender person. After getting a certificate as a transgender person, then you go back before the district magistrate with a medical certificate saying you've gone through surgery. Then you're right to be recognized as a man or a woman. There's two-step process that sets up for you to be recognized as a man or a woman. Again, this does great harm to the transgender community, because the transgender community is a diverse community, and they want recognition for a range of gender identities and gender expressions, all of which the transgender bill really destroys. Yeah, I'm done.
Rajvel?
Yeah, that's it. Thank you.
Nothing else? You want some concluding words, Arvind?
Yeah, no, I guess the concluding words will have to be on, I think, how does the LGBT struggle, in a sense, link up to the wider human rights struggle and the human rights movement? I think that's the question which has to be thought about and addressed. I think with respect to 377, it provides some part of the answer, right? Again, if you go back to the Navtej judgment and Justice Chandrachud's understanding of what is the unnatural what is carnal intercourse against the order of nature? He makes a very interesting point. He says that when you say order of nature, in a purely physiological or biological sense, it could mean relationship between between man and man against the order of nature, woman and woman against the order of nature. But he says when you impose the idea of unnatural within the context of Indian society, then it takes on a very, very different dimension. He says in India, the what is unnatural are inter-caste relationships, inter-religious relationships, relationships with Dalit men with Brahmin women. All of these come within the idea of unnatural. So if our objective is to contest or challenge the idea of natural, we have to move from saying that the right to love is a right for the LGBT community to saying the right to love is a right for all of us. Because the right to challenge societal structures of domination and repression. That's one dimension. And the other quick point I'll make is with respect to this, which came up again with respect to the protesting on the CAA and NRC. Again, it's important to see how the CAA NRC process may affect the LGBT community, and especially with respect to the NRC and the requirement of documentation to prove that you're a citizen. LGBT people sometimes might be in a difficult, strained relationship with their families, with their natal families. So it's very, very difficult to go back to your family and get those documentation to prove that you're a citizen of this country. So it places LGBT people in a slightly difficult position to the CA and NRC process. The second part, of course, is transgender community, and the idea of getting your documentation such a difficult one as it is, and imposing another requirement on the transgender community of getting a certificate to prove your citizenship. So there's a range of ways in which the LGBT community and the struggle can link up to the wider human rights movement, and that's something we need to think about a little bit more in the future as well.
Thank you, Arvind. I'm sure it's going to leave a number of us thinking in this audience. I wanted to close this session with a story, which was a very, very. I may not be a narrator who can narrate it the way it should be narrated, but I will anyhow try. In the year 2008, when we had our first Universal Periodic Review preparatory sessions, I remember meeting in Delhi, and we were a small group of about 30 people across the country from various thematic engagements in human rights. And there were also two representatives from the LGBTQI community. And these were all discussions on how each one's human rights issues should get into the UPR civil society report. And of course, as the one was initiating that process those days, I looked at them and once or twice in the session invited them and made them speak, etc., etc. And then the 2-day program was over, and there was somebody else who was taking over. The second day, when the program was over, they came up to me. Unfortunately, those days, at that particular point of time, my leg was in a cast, and therefore I couldn't move. Something which all of us have to get accustomed to understand what disability rights are. So I had traveled all the way from Madurai, flying with this knee in cast, and you can imagine my height, knee in cast. So they had to come to me, and they came to me, and they had tears in their eyes, and I was very moved. And I did not know what had happened to the program that made them so upset. So I said, did anything go wrong? I was so apologetic, I was so careful that something had gone wrong. And they said, sorry, nothing has gone wrong. This is the first time something has happened right. And we want to convey that to you. And we are emotional because it has never happened. The human rights community in this country has never considered us as part of the human rights community, is what they conveyed to me. And I felt ashamed, so ashamed. I could have rejoiced, but I felt very ashamed. As I felt ashamed the other day when Deepak Nathan pointed out to me and People's Watch and IHRE and all of us who have organized this program of why we don't have a sign language interpreter, which could have brought in a whole set of other participants to this program. I think for all of us who continue to think about human rights and how fulfilling we are, how wholesome we are in our understanding, I think every day is a challenge. And that day was my greatest challenge. I will never forget those tears, which I was so ashamed of. And then I realized it was their way of appreciating that everybody considers their issues also as human rights issues. I think that is the question you are leaving us with. And the last thing that you said was, how do you integrate into the larger human rights community? How does the larger human rights community integrate their issues also as part of the human rights issues? Are we only going to talk about torture? Are we only going to talk about right to food? Are we only going to talk about rights of children, rights of women, etc., excluding them? No. The human rights community has to include all of these peoples into our discourse. I think that is what you're leaving us with, Arvind, and I think that is what I'm leaving for the participants also to think. Thank you very much for being with us. Thank you very much.
Thank you, Henry. Thank you.
Nandini, I'm in a session. I'll give you a call immediately when it's over. 5:30. Thank you. Yeah, friends, we have the second part of this session. Again, another very interesting personality, very special personality, and I would want to introduce her. Can Shivani be seen? Yes, there she is.
Yes, hello.
Good afternoon, Shivani. Good afternoon.
Good afternoon.
I'm seeing you after a long time.
Yes, good to see you, Henry.
Very, very long
Thanks
time.
for inviting me so much. Yes.
No, it was a pleasure. We could not have done this course without you, and the participants will agree with me at the end of the session.
I hope so.
I've the pleasure of having also worked with Shivani, sitting in her office, and therefore I know her as a co-worker, as a co-engager, as we have worked together in the same premises. That's different from knowing people and keeping our distances from people, etc. She's the executive director of Housing and Land Rights Network in India, based in New Delhi from 2004. And she's here to make us all understand that housing rights, right to shelter, are also human rights. And you would have all seen this connecting when we looked at the right to life, that includes the right to housing. But her perceptions today are going to be very, very strong. She had worked with the Center for International Environmental Law in the US prior to Housing and Land Rights Network in India. She finished her BA in economics from the Bombay University and her MA in environmental studies in the US. She's been working in the field of human rights for over 20 years with special focus on economic, social, and cultural rights, especially the human right to adequate housing, land, livelihood, and the environment. She's been engaged actively with issues related to forced evictions, displacement, homelessness, land rights, the right to the city, don't forget our smart cities, disasters, climate justice, discrimination, sustainable development, women's rights and human rights education, etc. She's a trainer in human rights, and she also has participated in developing various international standards. And I told you when I was introducing Arvind Narrain that the next speaker also has that experience of having participated in processes where international standards are developed. And this includes the UN guiding principles on security of tenure for the urban poor and the UN Declaration on the Rights of Peasants and other people working in rural areas. This is a very special expertise that very few people in this country possess. And here we have one of our experts who would be able to tell you how these principles are developed. She's associated with various national and international networks. Of course, with the Working Group on Human Rights in India and the UN that you've heard of from day one. She works with the Urban Rights Forum for the homeless in Delhi. Very active during summer with the issues of homeless in Delhi. Extremely active in winter with the issues of the homeless once again. This is a very interesting office where the associations and the platforms working among the homeless immediately meet to see what has to be done for them. She's also a member of the Government of India's Ministry of Rural Development Task Force on Land Reforms and contributed to the drafting of the National Land Reform Policy of 2013 and the drafting of the National Right to Homestead Bill of 2013. She addresses in the United Nations. She participates in a variety of international conferences as well as in the European Parliament. She's a writer and has several publications, very, very meaningful publications to her credit. So, over to you, Shivani. We look forward to hearing you, and I'm sure participants will not forget that this is another expert with experience of the international and the domestic, and therefore any questions you want to link the international and the domestic, here is your last chance. Don't miss it. Over to you, Shivani.
Okay. So can everybody see me?
Yes.
Yes. So thank you so much, Henry, for inviting me to speak here, and for that very long introduction. A very good evening to all the participants. And this is, as Arvind also mentioned, a bit of a strange format because, while technology is great and, we can have these sessions while in lockdown and in different parts of the world. And the challenge is that we can't really interact and, we can't see one another. And a lot of, I think, speaking is about seeing people and, also being able to engage. So I'll try to do my best. I think you all have had a very good sessions so far, looking at various impacts of human rights, various dimensions of human rights. And I have a PPT, unlike Arvind, so I'll try to go through it, but I'll really welcome questions and discussions at the end. And the topic today is the human right to adequate housing. And, a lot of people, when they think of housing, they think of a structure, they think of, 4 walls and a roof, and they look at it as real estate, commercial asset. But really, housing is a human right. And I really hope by the end of this half an hour, you will really be convinced. And I'm sure, in the discussion so far, many of you are already aware of what housing really entails, right? And I think one of the basic principles of human rights is, the right to live with dignity, very closely linked to the right to life. And housing really encompasses various elements required to live with dignity. And in the international legal framework, it is an essential component of the human right to an adequate standard of living, which has been upheld in international law ratified by India also. And we see that it's integrally linked with several human rights. So everybody can see the screen clearly, the PPT? Yeah, okay. So I think you're familiar with the United Nations system, and we have a special rapporteur, an independent expert that is appointed on various thematic issues. And since 2000, we have a rapporteur on the right to housing at the United Nations. And the first special rapporteur actually gave us a very comprehensive definition. And I'll just read it out. It's the right of every man, woman, youth, and child. And I would also add, a transgender person here, because, or person of any gender identity, to gain and sustain a safe and secure home and community in which to live in peace and dignity. And I've underlined these 4 words because really this is the crux, the safety, security, home, peace, and dignity. And which is why it brings together various human rights. And as you will see, the right to life is very, very important. And I think the situation, the circumstances we're living in today of this COVID-19 pandemic has really brought to the center how human rights are linked. everybody's talking about the need to stay at home. But what happens if you don't have a home? Everybody's talking about the need to have physical distancing. What happens if you're 8 people living in one room, or 12 people living in a room? How do you distance? Everybody's talking about the need to have frequent hand washing. How do people wash their hands when they have one bucket of water, to last them for one family for the whole day? So I think this interlinkages between the right to housing, the right to life, the right to health. We have always understood them, people working on these issues, but I think for the mainstream, it has become very real. It has become very urgent that housing is, very much linked to the right to health and to the right to life. So for example, as Henry mentioned, homeless people, they die in the summer from the heat because they have no shelter or roof over their heads. They die in the winter. They die in the monsoons because they get wet and they have no place to dry themselves and they get sick. So the right to life is very integrally linked to the right to housing. But of course, as I mentioned, water, sanitation, the right to work. So if you live very far away or you don't have a house close to where you work, you can't really exercise your right to work. And the migrant workers crisis that, again, this pandemic has made so real for this country is the link between housing and work, because so many of these migrant workers were actually sleeping in their workplaces. They were sleeping in factories, they were sleeping in the shops, or many of them were renting one room. And the minute you had the lockdown and these commercial enterprises closed, many of them live on construction sites in tents, with their families. So we realized that nobody was looking at their right to housing. And I think that's something, again, that was very much brought to the mainstream by this crisis. And it's tragic that we need crises to, make us understand the importance of these human rights. But sadly, that is the way things are in this country. It's also linked to children's right to education. If children don't have a secure home, they can't study properly. They need electricity, but they also need safety. And we see, especially for women, the lack of housing makes them very vulnerable to all kinds of violence, including sexual violence and a higher risk of trafficking and abuse. So I think ultimately, as I mentioned, it is linked to the right to live with dignity. Yeah, so globally, these are all United Nations estimates. About 1.8 billion people lack adequate housing. 1 billion live in settlements, which the Indian government calls slums. And we don't use that word because it has negative connotations, including in many languages. Over 150 million people are homeless. That is, they have absolutely no form of housing. And about 15 million people are forcibly evicted every year. So they lose their homes for a range of reasons, and they are evicted from their homes. In India, the situation is also quite alarming. So according to census data, about 65 to 75 million people live in these urban settlements without access to basic services. And I think all of us who live in India have at some point seen these settlements and understand, how people live without adequate space in very densely populated, congested homes without access to services. About 4 million are homeless, and this is an estimate of the Supreme Court commissioners in the right to food case. And I think you may have heard of this case, in the discussion on the right to food. And then in rural areas, this is the socio-economic caste census, which tells us that about 101 million households are landless. So that would be at least 500 million people do not own the land that they live or work on. And one of the biggest crises is that our government doesn't invest in affordable housing. So you might have schemes, like Pradhan Mantri Awas Yojana, which talks about housing for all, but there's no definition of affordable housing based on income. So, what is considered affordable for the real estate sector is not affordable for a low income family. And that's the big gap in policy and practice that we're seeing. And in our organization, the Housing and Land Rights Network, we have been documenting forced evictions because there is no data in the country on how many people are being evicted by government projects or, city beautification, urban renewal, development projects, dams, mining. And so we started documenting, and just in 2 years, 2017 and 18, we found over 460,000 people across rural and urban India evicted. So if you do some calculations, that comes to 26 people losing their homes every hour. That's 26 people losing their homes every hour. So these are people who build their homes with their hard-earned savings, their own labor. Gradually over several years, they build maybe one wall, then the roof, then another wall. And then the government just comes and demolishes the home, calls them illegal, it calls them encroachers, or a road needs to be built. And generally, in 90% of the cases that we have documented, they are not even given a notification. So these are some families affected by forced evictions. Okay, so just continuing in the challenges that I was talking about, then we have, an increasing trend of what we call financialization of housing and land. And as I mentioned, then, housing becomes property, it becomes wealth, it becomes real estate, and people are speculating on it. So it becomes more and more affordable, but the government doesn't control this because in India, especially, housing is not recognized as a human right by the center or the state. And I think that's a big challenge. So in all the human rights work, when you go to the government, they will say, yes, health is a human right, food is a human right, water is a human right. But when it comes to housing, in the government's mindset, they still do not view housing as a human right, even though India has ratified international law, which says that housing must be treated as a human right. And this is a big challenge for those of us working in this sector to, get government policies to recognize and uphold the right to housing as a human right. And then we're also seeing disasters. Again, in disasters, those who live in inadequate housing are most vulnerable because of the poor quality of the housing, and then they lose their homes. And then we're seeing all this giving rise to much greater economic, social, spatial inequality. And if you look at how land in cities is distributed, you'll find that the urban poor or the rural poor, they occupy a very small percentage of the land. And even then, the conditions are so inadequate. For example, in Delhi, the urban poor consist of about 60% of the city's population, occupying about 5% of the land. So there's a huge injustice in the way we design our cities, in the way we allocate land, in the way we build housing. And again, it's the urban poor who build the cities, who build the homes, but the irony is that they do not have a space to call home for them. So this is a map actually of evictions across over 2 years, and the ones in yellow are smart cities. So Henry mentioned, we're also tracking what's happening to these smart cities, but these are evictions taking place across 2 years. So it's pretty much across the country that you see forced evictions taking place. So I don't know if there's time, but I wanted to just play a very short video just for a second. Can you hear this?
No. I think you'll have to share the screen for us to see the video.
Is it not coming?
No.
Oh.
Yoshi.
Okay, maybe we can just skip this video. I'm not able to get it. Can you see my screen now?
No, not yet.
Oh.
Yes, we can see it now.
Yeah,
Can you hear?
we can't hear, we can see.
We can't hear.
You have to start the volume.
Oh, no. No.
The volume is switched off.
I can't see it anywhere.
There's a small little, yeah, this place. On the right hand side, the volume is the right hand side.
Yes, yes.
That day court order in March 2000.
थोड़ा सा प्रयास करें क्योंकि जो है ईद का त्योहार है इस विषय में जो है मैं आप सभी से गुजारिश है मैं बोले थोड़ा बहुत भी सामान उमान है थोड़ा सा हटा नहीं दे बोला नहीं हट जा मेरे को धक्का देने लगा लगा दिया लाके अब मैं व्रत कर रखी थी मैं परेशान हूँ रोजा में कैसे अकेली हटाती कोई राहत था नहीं यहाँ पे हमारा कम से कम साल का 2 लाख रुपए का नुकसान है इसमें
Following demolition by the railway police, residents of Shakur Basti are feeling helpless, not knowing where to go now. Despite the Delhi High Court order in March 2019 stating clearly that they should be rehabilitated before undertaking any demolition process, the railways have clearly ignored the High Court order.
Hello?
Yeah. Stopped. Can you hear me? It stopped.
Yes, now can you see?
Now we can see.
Okay. So that was just a very short clip to highlight the kind of brutality involved in enforced evictions. You know, people are not given any notice. They're already extremely poor and they don't even given time to take out their belongings from their homes. And the bulldozer just demolishes them. They're left homeless. These are some more images. This is also from Delhi, where again there was police violence used against people. This is also from Delhi. You can see people just left on the roadside, you know, with some belongings, but mostly everything destroyed. This is in Bangalore, in Ijipura. This was a very big case in the news also. And till now, 2013 was the eviction. It's 2020. The land is still lying unused, but no rehabilitation given to the people. And there's a big builder lobby involved in this eviction. So this is also in Delhi, and a very large police force, and houses completely reduced to rubble, and till date, no compensation, no rehabilitation. Because in the minds of the state, the poor are always viewed as illegal, even though the eviction processes are actually following complete illegality. So women and children are much more impacted by evictions because they are rendered homeless or forced to move to inadequate housing. Another very big violation of the right to housing is homelessness. And in our work in Delhi, we found a large number of people are homeless because they lose their homes to evictions, they do not get resettlement. But also a large number are homeless because they do not earn enough money to afford even, you know, a room in a settlement. So you have whole families living on sidewalks, under flyovers. Now this is a very ironic photograph. You'll see there's a flyover behind which has very bright lights where these families used to live. But Delhi in 2017 launched what they call a beautification drive. So under the flyover, they have planted all these plants and very bright lights, but the people are pushed right onto the street. So it's a very cruel notion we have of beauty, of aesthetics in a city where, you know, there even the flyover, which was the only shelter people had from the rain and the hot sun, is taken away from them under the guise of beautification. This is India's capital, you know, which has about 1.5 to 2 lakh homeless people. These are people sleeping in the middle of the road on a road divider. So you can understand why homeless people die when there are road accidents, because they're sleeping in such precarious conditions. And this is in the peak of summer, you know, in the month of May, where it's so hot that they have no other place to go to. Now, Delhi has some of the best shelters in the country, but again, you can see, what a good shelter looks like. And these are temporary arrangements, emergency arrangements, but at the state level, at the policy level in the country, we have, shelters for the homeless is there under the National Urban Livelihood Mission. There is no scheme to enable homeless people to get housing. And if you really considered housing as a human right, then you would understand that everybody needs space to live in. They need privacy. And even now in the COVID-19 crisis, there's some distance being enforced in these same kind of shelters. Maybe, there's like 6 feet between people. But again, everybody's in one room, so if one homeless person gets sick or gets the virus, everybody gets it. But what people forget is that homeless people suffer disproportionately from TB. So people living in shelters, it spreads very fast. They have many, many serious health impacts, and thus they have a much higher morbidity rate and a higher mortality rate than the normal population. So if you're homeless, you're 5 times more likely to die than another person who has a home of the same age. So it's a very serious right to life and right to health issue. So I know you have gone through international law, and I think you've had session on international law, but Henry just wanted me to just run through some of the international provisions that specifically recognize the right to housing as a human right. So I'll just mention these declarations. We don't have much time. So the Universal Declaration of Human Rights, the Covenant on Economic, Social and Cultural Rights, the Convention on the Status of Refugees, the International Convention on the Elimination of All Forms of Racial Discrimination, the Covenant on Civil and Political Rights, which also recognizes the right to security of the person and home, which is directly linked to the right to adequate housing as well as the right to property. Then for women, as I mentioned, housing is really important, and the convention, the CEDAW Convention, also recognizes the right of rural women to housing and land. The Convention on the Rights of the Child recognizes children's right to housing in 2 articles. And then the Convention on the Rights of Persons with Disabilities, which is the most recent human rights treaty from the United Nations, actually has very strong provisions recognizing the importance of housing as a human right for persons with disabilities, because they face a lot of discrimination if they do not have access to adequate housing. So this is again a photograph of a homeless family on the streets, and again women and children are disproportionately affected, and this is again under a very this is under a metro station in New Delhi. So you can see the stark inequalities, of the metro trains going above and people underneath just have no space to live. So I just want to spend a few minutes discussing how the right to housing has evolved at the United Nations. And as many of you would know, an international treaty just, talks about the right, like everybody has the right to housing must be enforced by the states who are signatories and who ratify the treaty. But it doesn't really explain what the right to housing is. So there is work done by treaty bodies at the United Nations, the Human Rights Council, the Special Rapporteurs on Adequate Housing, and just now we have fourth rapporteur who's been appointed. He's of Indian origin, but he's an American citizen. And we've had international declarations, global conferences and their outcome documents. And then the Office of the High Commissioner for Human Rights often organizes what are called expert group meetings to develop specific guidelines. And I'll just give you a few examples of these. So when we speak of the right to housing, the most important document for those who are interested, you could look this up, is General Comment 4, which explains the normative content of, what does the right to housing mean? And it came up with these 7 elements. And so, for example, the second one is the availability of services. So it talks about the importance of water, sanitation, electricity in your house. It talks about habitability. That means, your house must protect you from extreme weather conditions, the heat and the cold. It should be, there must be space for everybody. It should have adequate light and ventilation. Location is really important. As I mentioned, it needs to be close to people's places of work, education, study, and it should not be, in any precarious location or close to an industry. And we find in all our cities, the poor actually living in places which are very threatening to their health and their well-being. So these are the elements, and the first one is the legal security of tenure. That means that everybody's right to housing should be recognized and they should not be evicted. So if you see how, again, the poor live, they do not have documents. So even when they live on rent, they do not have rental agreements because they are considered informal. Everything to do with the poor is considered informal in this country. And so we do not have laws that are, applicable to them because we exclude them in these ways and we don't give them titles, we don't give them documents. So it becomes very easy to evict them. Now, when any government has, say, a resettlement policy, it asks the poor to prove that, you should prove that you have been living in the city before a certain date. And they need documents to prove that. But very often the documents get destroyed during an eviction, or they don't have the documents because they have been denied those documents. And thus becomes very easy to evict them. So if all these elements are ensured by the state, then housing is adequate. And that's why we keep talking about the right to adequate housing, not just the right to housing, because it's not just any kind of housing that could be considered worth living in. And then the work of the special rapporteurs have built on these elements, and they introduced 8 more elements, for example, access to natural resources, access to remedies, freedom from violence against women, which is also really important and something that we need to really look at. Again, when you've looked at the lockdown, some of you may have seen in the news that domestic violence really increased across the world, not just in India, because women, again, are trapped in homes with the abuser. There's no escape from them. Child abuse has really increased during the lockdown, again, because children are, in confined spaces with the perpetrators and they haven't been able to escape. So again, when you talk about housing, it has to be safe, it has to be secure, and it has to provide protection from violence for women and children. So another important standard from the United Nations is, again, General Comment 7 by the committee. It defines evictions, and then it lays down, what states need to do to prevent evictions. And they also need to take action against third parties that carry out evictions. So the UN Special Rapporteurs have done some really great work, and I'm mentioning 4 of these standards, and 3, actually the last one also I was involved in preparing, and the first 2 also. So again, these are standards that lay down, what are state duties and responsibilities to prevent evictions, to provide resettlement. The second one talks about the need to recognize different kinds of tenure security, so not just ownership, rental housing, it talks about collective housing, it talks about group housing. So it says that, there should be a spectrum and there should be flexibility of tenure, but everybody must be given security of tenure. And then the last one actually is really important because the rapporteur who just finished her mandate, Leilani Farah, after 6 years of work, she wanted to leave the world with some guidelines, and explaining to governments, how do you implement the right to housing? So, a lot of people say that, oh, it's great, we have this right. How do we implement it? And I think these guidelines really lay down some very important principles and guidance for governments to implement the right to housing. For those of you who are interested, it's all available on the website of the Special Rapporteur on Adequate Housing. And then in terms of the UN Habitat, again, which is the UN agency working on habitat issues, they have a conference every 20 years, and they have these 3 outcome documents, which are important also in building and looking at different issues related to housing and habitat issues. The last one actually looked more at urban issues, and for people who work on the continuum of housing and the continuum of urban-rural, we really felt it had excluded rural areas, and that was a big shortcoming of the new urban agenda. But it's cited a lot by governments, and again, it recognized the right to the city, which was an important development, which says that everybody living in the city has an equal right to participate in the city and also to share the benefits of the city. Right, and then these are some other principles on internal displacement, really important. And as I mentioned, India has a very high number of people who are internally displaced, including for development projects, but we have no policy for them in the country. And then the Declaration on the Rights of Indigenous Peoples, which recognizes the right to land very strongly. And I just want to take 2 minutes to stress on the indivisibility of land rights with housing rights. So, you can have housing, but you also need land to live on. And that's why the right to land is really important. We do not have the right to land recognized as a human right in international law, except for indigenous peoples. But there is work going on at the UN Committee on Economic, Social, Cultural Rights to develop a new general comment on the right to land. And, we are really hoping that the right to land is also recognized, because a very large percentage of the world's population directly depends on land for their right to life and their survival. I think most of you are familiar with the Sustainable Development Agenda, which gave us the Sustainable Development Goals. And that's also important in the work that we do. Again, CEDAW recommendation on the rights of rural women is really important. And the last one, again, recognizes the right to housing and land for rural people in a very strong way. And I think it's a very historic declaration. And India at the Human Rights Council actually greatly supported this declaration. So we don't have that very often, that Indian government supports something like this so strongly. So we are really hoping to try to get it more implemented in India, because, as you know, the agrarian crisis is so severe. The crisis of farmer suicides is so severe. And now with this reverse migration, again, we really need to make sure that we have adequate investment and jobs in rural areas, so that people also have a right to their land when they move back and forth between cities and villages. So before I end, I just want to stress on the importance of rights to housing and land for women. We have seen a direct link between housing and violence against women, and there are several studies that say that if women have housing in their names, they are 8 times less likely to experience domestic violence. So it not just gives them economic empowerment and security, but also physical security. So if there is violence, then they can stay in the house and the perpetrator can be asked to leave. But if women do not have titles over the land, then they are evicted and they are thrown out. They're thrown out when they lose a partner. They're thrown out for various reasons. And therefore, we need security of land tenure in the names of women. And the Indian government has, in all its policies, called for joint titling in the names of men and women, which is a good step, but it's not adequately implemented. And for single women, there are not enough protections. And single women are also a group that face a lot of discrimination in terms of access to housing and land. Also, women produce 80% of the world's food, but are not recognized as farmers. And that's also linked a lot to their land rights. And, since Arvind just spoke, I also wanted to mention that the increasing discrimination against LGBTQI persons, transgender persons. They find it much harder to get access to housing, and they also face bigger discrimination in terms of accessing the equal right to housing because of the stigma attached, and a lot of people actually violate their right to housing. So these are things we need to be aware of, and make sure that these protections are ensured for discriminated and persecuted groups in the country. And again, even within urban and rural areas, we see that caste plays a very big role in discrimination, especially in land. And land is used to perpetuate violence against Dalits across the country. Their homes are burnt, and it becomes a source of great violence and conflict, and they are also denied their land. So I mentioned in the beginning the percentage of landless households in India. A very large percentage of them are actually Dalits and low caste families. So we need to be aware that when we talk about the right to housing, the non-discrimination principle of human rights really needs to be pushed, because we see so many levels of discrimination and exclusion in terms of access to housing in India, but also in other parts of the world. So yeah, I think in terms of moving forward, I'm not going to give a lot of recommendations, but we really need a human rights-based approach. There is a global housing crisis, and until states really realize that housing is a human right and not a commodity. It's not real estate. It's not a marketable asset. Until then, we're not going to be able to solve the crisis. And really hoping that this pandemic, draws attention on it. But we're already seeing that, the economy and the market is in India's, relief package. That's what's getting the push. And so we need to see that we really keep human rights at the center of any kind of response and relief to the current crisis also. That's an organization. We have a website. We also have a Twitter handle. For those of you who are passionate about these issues, you can follow us, and you can email me. And also Henry has my contact information. So I've lost track of time. I don't know how much time I've taken, Henry. I'm sorry, but I'll stop here, and I'll be happy to answer any questions. So thank you so much for listening, and I hope I wasn't too fast.
No, Shivani, you are fine. Except that I'm sure there are questions. Rajwell, 2 questions.
Yeah, so I have 2 important questions as such. The first one is related to forced eviction. A participant asks, so how do we challenge it, and what law says about it? And especially with respect to the relocation to these people who are evicted is given in places that are in the outskirts of the cities, and they lose job opportunities and other multiple opportunities in that. So that's the first question. The second question is with respect to the government's ambitious smart city project. So the participant's question is whether any social impact assessment is being undertaken before these smart city projects are being designed or developed. Shivani, can you hear?
Shivani, can you hear? I think she lost you.
Yeah.
Because she's not moving. Shivani? Shivani? You'll have to remove the screen.
Yeah, I'm removing.
Shivani? Just call her on the phone and tell her. Yeah, something I can find. Hello? Hello? Okay. Till she comes in, and am I audible?
Yes, you are.
Till she see some movement there. It's important for all of us to know that the Housing and Land Rights Network undertakes cases of evictions in courts and supports groups that work across the country on evictions. So the first thing I want to tell you is, you have an eviction in your city, you don't know what to do, this is an organization that you can contact, because Shivani and team would be able to put you in touch with the right type of people or the right type of lawyers who will be handling these issues in that particular city. That's number 1. Shivani got cut off. We are just admitting her back. Shivani? Shivani?
Yeah, she's joining. Power went off in the office.
Delhi lost power. So friends, keep this in mind. When you have issues of eviction of the poor, Shivani is somebody whom you can always contact. And she's quite active. Please visit their website. I'm going to ensure, if I give a homework, if I give an activity today, they will murder me. So I'm not doing it today. That is a website which you should definitely visit. Shivani, you're there?
Hello, Henry.
We can hear you slightly. Yes?
Yeah, okay. So I've tried to put it through the mobile. It's very weak connection. So maybe I can just use the audio. The video is not coming on.
But we can hear you very well. You got the questions?
No, I'm sorry. The electricity went off, so I
Don't
just
worry.
lost the connection.
Don't worry. Rajwell, can you repeat?
Yeah. Shivani, there are two.
One question.
Okay. So it's about post eviction.
Yes.
How do we challenge it and what law says about it? And this is with respect to the relocation to these people, to the persons who are evicted, which is being given in areas outside the city, due to which they lose job opportunities and income.
Sure. So I think we actually have some good judgments, and I can send you a link also. We have compiled judgments of high courts that have recognized the right to housing. So I think legal remedy is really going to. Uh, Unfortunately, we have not got judgments that are very strongly recognize the right to housing, but we have a lot of judgments that have stopped evictions. So courts have given us stay orders and left it at that, and then mostly people have rebuilt their houses. The UN guidelines on evictions, they call for due process, and 2-3 judgments of the Delhi High Court have actually cited these guidelines. So I think part of the challenge is also getting the judiciary aware of human rights. And Henry will tell you that there's a lot of work that needs to be done with judicial academies, judges, because the more they know about these standards, the more likely they are will use them in their work. Because very often we have judges using words like the poor are encroachers and they have no right to be here, and so they should be evicted and they should be resettled outside the city. But fortunately, we've had good justices, like Justice A.P. Shah, Justice Muralidhar, who've given us some very good judgments. So I think, building on that, using legal precedent is important. But with the government authorities, it continues to be a very big challenge. And, even when court judgments say that resettlement should be in situ, the government will always come back and say there's no land for the poor, and they'll be, pushed to these resettlement sites like Kannagi Nagar in Chennai, or Dwarka in Delhi, which are outside the city and do not have jobs and opportunities. So I think it's a very big challenge still for India, but fortunately we have some good judgments that I can share also with people who are interested.
We will collect the judgments from you and pass it on to our participants. I was telling them when you were not here that if they have cases of evictions in their own cities, HRLN is an organization that they can always feel free to communicate with. I told
yes,
them
and
that.
using because of this crisis, our publication has got delayed, but we will be releasing our 2019 eviction report. So if anybody has cases of 2019 that you're aware of, you can immediately let me know, and we will include it in the publication.
Very good. So I would like to thank you, Shivani, because it's time, and our closing remarks are also there for the participants. Thank you very much for being with us. I'm sure.
Thank you so
I'm
much.
Sure
Thank you
people
so
are
much
able
for
to
inviting
see
me.
this whole
Sorry
question
for this
of
technical lapse at the end, but fortunately the power was there throughout. So I wish all the students and participants and all the senior people in the group all the very best, and hopefully one day we can have a personal interaction.
Yeah, the reason, and I want to tell the participant, the reason why we are doing this is not because in this half an hour you will get everything, but it is to give you different aspects of what human rights are and put you in touch with people who will act, who will engage, who will communicate with you. And these are people who are connected with the grassroots. Now, don't forget that Milun Kothari, whom you met on the first day, who delivered our keynote address, has been the founder of the Housing and Land Rights Network. 2, he was the first UN Special Rapporteur on the right to adequate housing. So many standards that are being referred here are standards that Milun and Shivani worked together when he was the Special Rapporteur there. So that's very important to know. Third.
Yeah, thanks for mentioning that. Yes.
Yeah, they know, they've seen Milun, so I think it's important that we make that connection. And they know him now as a Special Rapporteur. the incoming special rapporteur is Professor Balakrishnan from Tamil Nadu. From Tamil Nadu, has been very much engaged with tsunami work in Tamil Nadu. During tsunami, he was here and worked with several projects here. He teaches at the MIT, and now he is the special rapporteur on right to adequate housing. So these are all connections, and if you want to connect with the special rapporteur on housing, the gateway is with Shivani and her organization. These are people who are very well connected because they take the issues of the homeless, those who suffer from the right to housing, to the international special rapporteurs and other treaty bodies. Thank you, Shivani. Friends, I want to tell you that today, kindly spend a little more time in your group. Today is Tuesday. You all know that you had a small little compulsory activity for today. The activity was built into two steps. The first step is your question for the RTI. Draft your question for the RTI, we are told. I hope you will be able to present your questions in your group to the facilitator. And it will be nice to see whether the question is approved by your group as well, so that it is clear. And if it is clear, then the second part of the question is, do you have your PIO identified? The information officer to whom the question has to be sent. And then third, we will then go tomorrow into how you sent that question online to the department or the ministry to whom it is supposed to be addressed. This was something that you had to do. Kindly ensure that you do it. Now, friends, we've had the standard absentees. Morning we had first session 20, second session 23, this session, both the sessions, 20 absentees. We see that the same absentees are not continuing, so I'm sure there are some emergencies that people have to attend to, some courses. Some people are very kind enough to excuse themselves. They sent us a small note, and I want to respect them and value that very much for keeping us informed. These details of your absentees, those who are absent, is coming to your facilitator. So please discuss with your facilitator. Supposing we had made a mistake, it is your job to bring it to our notice immediately. Don't come after some time and say, you know, on the 12th of May afternoon I was present. Unfortunately, we work in human rights. There was somebody in some group who had attempted to argue with my colleague, saying that they were present, and then it was proved that that person came only at 9:45 for the second session, and then the person agreed, yes, it came. And I know this is from Victor's group. So we have accurate information to the best of our ability, but we are human beings, we can make mistakes. So if we have made mistakes, we should correct ourselves, but you should be able to come to us and tell us that there is some mistake that has taken place. Facilitators, please let the attendance, the absentees list from your group will be mentioned to the group, so that if there is a mistake, you yourself can bring it to the attention of Ganesan, and through Ganesan to Priya, who's maintaining. Attendance will be important in terms of and we don't find anybody consistently absent, so we don't have any major problems here. People are asking, is it 75% attendance? Is it 80% attendance? I would prefer to say it is 100% attendance, so that everybody comes closer to attending more sessions. Let's not get into, if there are genuine reasons for being absent, we respect that. So we are not going to reflect that, but we'd like you to know what is the situation. So friends, we have the 9th day over. We are going to the 10th day. Tomorrow we will be dealing with the rights of the elderly. We will be dealing with the right to health. We will be reading on refugee rights and human rights, and then on the right to education. Very, very important. So you'll see the broad spectrum of rights, but all of them are connected to right to life, right to equality, right to liberty, and right to dignity. And today you are able to see the linkages: right to life connected with right to dignity, right to equality connected with dignity, right to liberty of people who are not citizens of this country, but since it's connected with right to life, therefore, though their right to life will also be able to be taken up in the courts of law. So you've seen the whole connection now. It's a very powerful definition of human rights we have of right to life, right to equality, right to liberty, and right to dignity of the individual, which we are, for convenience of study and examination, breaking it into so many different rights for us to understand the ramifications. And why? Not because of giving you a degree, because we want to ensure that the next time you have an eviction in your city in Mumbai, in your city in Ajmer, in your city in Kolkata, in your city somewhere in Hyderabad, or in eviction in Kodaikanal, eviction in Chennai, you will see it as a human rights violation. And therefore, you will take up this issue both in the courts of law as well as the national human rights institutions and the international mechanisms that we will be introducing you to. So it is not a question of knowledge, it's a question of knowledge, and then we will go to skills to ensure that we are able to act. Thank you. We have crossed the time today. I'm sorry. Thank you very much. There are still 176 of you here who respect and stay inside. Thank you very much. Once again, thanks to Shivani if she's here, and to Arvind Narrain as well, and to all of you for tolerating me past 5:30 today. Thank you very, very much.